Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.
People v. Kenneth Tyson, decided on March 17, 2026. Canataro, J. Defendant was indicted 14 months after he allegedly assaulted a corrections officer while incarcerated for a different crime. Both county court and the appellate division concluded that this pre-indictment delay violated defendant's due process rights. Considering the relevant factors according to our precedent, we disagree with the determinations below. We therefore reverse. On Christmas Day 2021, New York Department of Corrections and Community Supervision (DOCS) officers at Collins Correctional Facility conducted a welfare check on defendant Kenneth Tyson, who was serving a term of imprisonment for a separate conviction. When one of the officers entered his cell, defendant allegedly threw a brown liquid substance that smelled of feces, striking the officer. The officer was nauseated but otherwise unharmed. DOCS documented the scene, drew up reports, and sent the officer's uniform to the New York State Police Forensic Investigation Center, FIC, for serological testing a few days afterward. On February 28, 2022, DOCS sent FIC a bioscience request for priority case status to expedite the serological testing. On May 2, 2022, FIC reported that the uniform tested positive for urine. During this period, defendant was placed in solitary confinement in the facility's Special Housing Unit, SHU. Defendant was granted parole on his previous conviction in July 2022. On July 22, 2022, DOCS formally referred the incident to the New York State Police for prosecution. At some point in August 2022, the state police sent the referral and evidence package to the district attorney's office. In February 2023, defendant was charged by indictment with one count of aggravated harassment of an employee by an incarcerated individual, a Class E felony which criminalizes throwing bodily fluids on a corrections officer, Penal Law 240.32. Defendant moved to dismiss the indictment as violative of his constitutional speedy trial and due process rights. County Court granted the motion, and the appellate division affirmed. The majority held that the pre-indictment delay was unreasonable given that the case lacked complexity, the supporting evidence was available to the people within a short amount of time, and defendant had already served 7 months in solitary confinement as punishment for the incident. 2 justices dissented and would have reversed and denied the motion. The dissent opined that the delay was consistent with similar periods previously found to be within constitutional limits and that the people's deferral of prosecution to obtain additional evidence justified the delay. A dissenting justice granted the people leave to appeal to this court. By statute and constitutional law, New York guarantees criminal defendants the right to a speedy trial and prompt prosecution. People v. Regan, citing People v. Staley, People v. Vernace. This right necessarily prohibits unreasonable pre-indictment delay. People v. Singer. This court analyzes due process claims predicated on a pre-indictment delay by weighing the 5 factors set forth in People v. Taranovich. 1. The extent of the delay. 2. The reason for the delay. 3. The nature of the underlying charge. 4. Whether or not there has been an extended period of pre-trial incarceration. And 5. Whether or not there is any indication that the defense has been impaired by reason of the delay. See Vernace. The Taranovich framework is a holistic one, that is, no one factor or combination of the factors is necessarily decisive or determinative of the speedy trial claim. People v. Johnson, quoting Taranovich. Turning to the first factor, viewing the 14-month period from the time of the incident to the time of the indictment in its totality, we note that there is a large body of precedent denying speedy trial claims based on similar periods of pre-indictment delay. See e.g. Taranovich, 12 months, People v. Williams, 14 months, People v. Polvino, 21 months, People v. Robinson, 16 months, People v. Cheney, 14 months, People v. Arrington, 16 months. This factor counts somewhat in the people's favor. With respect to the second factor, the reason for the delay, the record reflects that docs proceeded with alacrity in the immediate aftermath of the incident, and that part of the delay attributable to the time it took the FIC to return the lab results was justifiable. See Regan noting 3-month delay in obtaining results from the FIC. To the extent that defendant argues that the people could have moved forward with prosecution without confirming the presence of urine, see People v. Ortiz, we note that lab testing confirms this element of the charge more reliably than witness testimony, and the prosecution should always endeavor to compile evidence not only sufficient to indict, but sufficient to prove its case beyond a reasonable doubt prior to seeking indictment. We find no fault with the decision to procure lab results here. That said, there is little to no explanation for the ensuing 9-month delay after the lab results were returned. We therefore deem this factor to weigh somewhat in defendant's favor. The third factor, the nature of the charges, does not favor either side. The prosecution's case does not appear to have been complicated. Further, although aggravated harassment of a DOCC's employee by an incarcerated individual is by no means a minor offense, it was not exceedingly serious, especially since the officer was not injured. Likewise, the fourth factor, pre-trial incarceration, does not favor either party. Although defendant was subjected to a lengthy stay in the SHU following the incident, neither his time in prison nor his time in solitary confinement would have been reduced by a quicker prosecution or even no prosecution at all. On the other hand, a defendant's status as an incarcerated individual cannot itself excuse the people's pre-indictment delay. See People v. Winfrey. The fifth factor, prejudice to the defense, weighs in the people's favor. Defendant's release and apparent success on parole is laudable, but it did not prejudice his ability to mount a defense on this new charge. While the people's justifications for the delay are lacking in some respects, balancing all 5 Taranovich factors, we conclude that defendant was not deprived of his constitutional right to a speedy trial. Accordingly, the order of the appellate division should be reversed, defendant's motion to dismiss the indictment denied, and the case remitted to county court for further proceedings on the indictment. Order reversed, defendant's motion to dismiss the indictment denied, and case remitted to county court, Erie County, for further proceedings on the indictment. Opinion by Judge Canataro. Chief Judge Wilson and Judges Garcia, Singas, and Halligan concur. Judge Rivera dissents and votes to affirm in an opinion, in which Judge Troutman concurs. Decided March 17, 2026.
Welcome to NYPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypt.com/law to read the full decision.